I know you referred to this in your first answer to the first question itself when I asked you about Paris. This is about regulating AI. You said we wanted to see how it shapes and how it develops before we make up our minds. But on the other side, there is a risk that regulations will fall behind the curve as well, because applications have started in India. A lot of companies are using AI applications. So, do you think it's time to look at a guardrails to be set up for AI usage in the country?
Quite honestly, I mean, it's a question of actually, if at all I were to look at regulation today, on today's date, I would look at what parts of regulation actually inhibit the acceptance or inhibit how AI can be rolled out, and see whether there's something we can do on that regulation. I mean, that would be the approach I would take today. You see, the reason I say this is two or threefold. You have to figure out where we are coming from. You have to see, why do you want the regulation? What needs to happen for the regulation to come in place? One thing that many people are worried about is misrepresentation and deepfakes and what kind of things are coming out. That, I think, fortunately, or whichever way you look at it, you belong to the media, you may not look at it as fortunate. In government, we believe it's fortunate that we have a legal position today which allows us to take action against certain kinds of content, right? And this is something which is baked into our constitution. We are not doing something which is unconstitutional. Article 19(2) of the constitution permits us to place certain reasonable restrictions on right to freedom of expression. And section 69A of the IT Act, actually out of the 9 or 10 clauses which can be used, or grounds on which freedom of speech can be curtailed, the section 69A contains only 6 grounds, which are basically security of the state, public order, and so on. So it's a very limited power, and we have that power. Now, that is not available in many Western countries, European countries, US and so on, where each case they have to get a court order. In our case, fortunately, it is an executive authority and it has been tested in the courts and held to be valid. So I think we have enough authority currently available under the existing legislation to address issues like deepfakes and misrepresentation. If at all we have an issue there, it is an issue of technology as to how quickly you can detect. That is about the only issue. But I think the existing framework of what is provided in the Indian Constitution with what is provided in the IT Act and the Bharat Nyaya Samhita, the BNS and others, is more than adequate to address these issues. We may have to sharpen technology tools to make sure that we are able to detect faster. So that is one set of harms that everyone keeps worrying about. The other thing is privacy and how data gets hoovered up and used. There are 2 dimensions to this. One dimension is individual privacy, and I think the Digital Data Protection Act takes care of personal data to a significant extent, and that's already been rolled out, so I don't think we need to do anything else on that front. The other part of it is copyrights. Now, copyrights is sitting in court as we speak, and that needs to be addressed. There are matters sitting in the court, and those will have to get addressed. So these 2 aspects, I think, more or less are the big worries. The other worry really is the bias element and so on. So the bias element and all of that is only by building your models, training more data that you can do. It's a technology question. It's a question of doing. It's not a question of what will happen. The third element is job losses. Now, job losses, as I already pointed out, I think India is situated a little differently. We don't have as many white-collar jobs that we have to worry about just now. The opportunities are greater than the risks, and therefore, I think that's what we need to focus on. And we have to fundamentally focus on skilling and reskilling to make sure that the human resources you have in this sector are deployed appropriately. And that doesn't require law. I mean, that requires action. So these are the 4 or 5 serious things. The last one, of course, is the existential threat. And I know that, say, the state of California considered a kill switch, which they themselves sort of rejected. So nobody is really going that way, and I don't think that's really the way we need to go. So having said that, I don't think regulation should play that role. If at all we need to look at it, we need to look at, in the copyright mechanism, is there some way we can legislate to make sure that if, mean, it's like you and I reading a book, right? At the time that you read a book, you're violating no copyright. It's only when you actually reproduce the book or reproduce elements of it verbatim that you're without attribution, that's when you're violating copyright. Now here the issue is that you have an artificial brain which reads everything and then uses it somewhere in the system. So if we can think of a mechanism for creator content which can actually be compensated in some way, as a journalist you will get this. So if you're compensated
it's a big problem for us.
So if it gets compensated in some way, then without actually going into a copyright violation and a complete sort of court related process, if we can sort of think of some regulation along those lines, it might be win-win for both sides. I mean, these are the kind of enabling things that I think we really need to think of.